Good evening. This is John Milburn for Laws 12063, Advanced Statutory Interpretation and Drafting. And this is week 5. Now, next week is a break, so there will be no live session, and we'll resume with week 6 in 2 weeks from tonight. So tonight being the 13th of August. So thank you very much, Nicole, for joining us. And for those of you watching the live session, watching the recorded session, please consider joining us live. So it does make it easier to be interactive in the approach if we have some participants. So don't worry, Nicole, when we only have 1 or 2 people, I don't ask questions, but please feel free to interrupt, ask questions or add comments as we go. So for all of you watching this as a recorded session, I hope by now that you're well advanced in preparing your material for the first assessment and finding an interesting topic, working through some of the rules that relate to statutory interpretation, and paying particular attention to the way in which you use your words for simplicity of language, and also ensuring that you follow grammatical rules. So we'll continue tonight with our discussion around grammar. Phrases and clauses is where we'll start. So phrases and clauses are groups of words, obviously within a sentence. They're not a sentence themselves, and they form. They serve a similar but different purpose. In that, the similarity is that they usually form a discrete, if you like, self-contained element within the sentence, and a phrase is a group of words that does not include a verb, but will provide some further information to assist in explaining the meaning of a sentence. A clause will do a similar thing, but importantly will include a verb. So it's potentially more complicated. And of course, verbs are extremely important, very powerful words within our language. So when you're drafting material, you need to pay particular attention to the verb that you use, and then consider those things around it, or those things which contain it, as being very important. So some examples of phrases. The sentence might be, the applicant contacted the respondent, and then here's the phrase, on 6 occasions between December and January. So the final part, the phrase at the conclusion of the sentence, provides further information, but it doesn't contain a verb. Another example, the purchaser arranged finance with Heritage Bank. So with Heritage Bank is the phrase, and again, you'll see that there's no verb. When it comes to clauses, they are generally of 2 types. They might be principal clauses or subordinate clauses. Now, as I mentioned, in both instances, the clause will contain a verb, and this will, of course, affect the rest of the sentence. So every clause is to be considered very carefully as you draft material because of the way in which it affects the overall meaning of the sentence. So what's the difference then between a principal clause and a subordinate clause? So a principal clause contains a subject and a verb, often more than that. So you can see that a principal clause theoretically could be a sentence on its own. Subordinate clauses obviously contain a verb, otherwise they'd be a phrase, but in a subordinate clause, it won't stand alone in a sentence. So, and then there are differences in clauses between noun clauses and adjectival clauses or adverbial clauses. So noun clauses contain that which would be a noun or a thing in a sentence, and the clause, the noun clause, gives form to the thing in the sentence without actually describing any of its characteristics. So an example of a noun clause in a simple sentence is, this is how he escaped. So in the sentence, the verb is the word is, and the subject is the word this. The object, that is the thing that is how he escaped. So you can see that the words he escaped collectively articulate a thing, which is a concept. So that's a noun clause. Contrast that to adjectival and adverbial clauses, which are descriptive in nature. So the idea of those type of clauses is to provide more information about some of the components of the sentence. So adjectival clauses usually tell us about the subject or the object, and adverbial clauses, of course, given the name, will tell us more about the verb. So some examples of that. The plaintiff, having experienced this situation previously, changed the locks. Or the clause could be at the end of the sentence, such as, the defendant brandished the knife in a threatening manner. And the applicant filed the document which complied with the court's requirements. So these are examples of clauses that are descriptive in nature, that enhance the meaning of the sentence, provide much more flavour to the sentence, but still retain that basic simplicity of the use of words, is what we need to achieve. We need to be very careful about how we use the words and use the clauses and phrases. So let me give you this example. The promisor will supply a flat screen television set, and the promisee will supply a refrigerator in working order. So does that mean, for instance, that the refrigerator must be in working order, but the TV need not be in working order? Does the description in working order apply to the TV or to the fridge or both? So you can see that sloppy drafting, imprecise language, can create a whole range of problems. There is an excellent way to consider the structure of a sentence from your study guide. I'll invite you to look at the way in which a sentence might be built by using phrases. So if you look at your study guide, you'll see that this section starts with a sentence, or what could be a sentence. The supplier agrees to deliver the car. It doesn't tell us very much. It could stand alone as a sentence. It would be very simple, but it tells us something about the fundamental obligation that the supplier has to do something. It's written in the active voice, which is good, but let's go further. And if we add a phrase to that, it says, the supplier agrees to deliver the car to the purchaser. Now, of course, to the purchaser could not stand alone in a sentence. It doesn't have a verb. But from a legal perspective, it's important as a phrase because it provides specific detail to clarify the obligation contained within the principal clause. In other words, if the supplier delivered the car to anyone else, then the supplier would not have met its obligation. So the obligation is for the supplier to deliver the car to the purchaser, an important phrase. Now, we could leave it at that. But let's go further and add another phrase. On Thursday, 10 January. So the supplier agrees to deliver the car to the purchaser on Thursday, 10 January. Again, collectively, that could be a sentence. But the additional phrase on Thursday, 10 January could not stand alone as a sentence. It doesn't have a verb. Therefore, again, it's a phrase. But once again, it's important because it provides another type of specific detail which affects the obligation imposed upon the supplier in the principal clause. In other words, Arguably, if the supplier delivers the car even to the purchaser, but on a different date, then the supplier may not have met its obligation. Let's take this sentence further. And so now it reads, the supplier agrees to deliver the car to the purchaser on Thursday, 10 January, and. So we've got this single word now, and in the context of the sentence, the word and, as is typically the case with that word, is a conjunction. What that means is that it's joining two separate clauses and it's specifying the relationship between them. Take the sentence further. The supplier agrees to deliver the car to the purchaser on Thursday, 10 January, and the purchaser agrees to inspect the car. Now, the words the purchaser agrees to inspect the car could stand alone as a sentence. We have a subject, which is the purchaser. We have a verb, agrees to accept, or inspect rather, and we have an object, that is the car. Again, it's written in the active voice, but because it is a clause, because it contains a verb, it will be a clause. Because it's something that could stand alone, it is a principal clause. Now, from a legal perspective, from a drafting perspective, it creates an entirely new obligation. And this time, the obligation is purported to refer to the purchaser. And we'll go further to complete this sentence so that it is the supplier agrees to deliver the car to the purchaser on Thursday, 10 January, and the purchaser agrees to inspect the car immediately upon delivery. Now, that's a phrase. There's no verb. It couldn't stand alone as a sentence. It does provide more information. And I guess the question then from a drafting perspective is, if the supplier delivers the car and the purchaser waits a few hours or a day or a week before inspecting the car, then arguably the purchaser would not have met his or her or their obligation. From a drafting perspective, this creates a whole range of difficulty because it means that not only do we have to convey something which is in our mind, but we have to do so with sufficient certainty that the reader of the material will have a clear understanding of the obligations that are imposed upon the parties. And following on from that sentence, you may be in a position to provide some further indication or information about sanctions, for example, for non-compliance. So the whole aim of, I guess, statutory interpretation and advanced drafting is that you're using language in as simple a way as possible to convey an accurate meaning. We're not really here to tell a story, but we're here to convey something in a very technical and tight manner. Conversely, if you're looking at material and you have a good understanding of the way in which sentences are structured, then you have an opportunity to attack the drafting, in other words, to mount an argument. So knowing something about the grammatical structure of a sentence will assist you in doing so. It will take you from thinking, well, something doesn't quite seem right, to no, that is not right, and I know why. So consider the study guide, the material in there, and have a look at this example. So imagine a contract specifies obligation A, which is future simple tense. The contractor will pour the concrete on the 1st of May, as opposed to obligation B, which is using future perfect tense. That is, the contractor will have poured the concrete on the 1st of May. Can you see the subtle difference? And that subtle difference was caused as a result of the use of different tenses imposed upon the contractor in relation to the obligation. The first was future simple, and the second was future perfect. So in that case, you could argue that it's not actually the same obligation. The way in which the words were used create an entirely different obligation. The first requires the action to happen on the 1st of May. It's very specific. It must be that day. The second obligation allows for it to occur beforehand, the only requirement being that it must have been poured by the 1st of May. Now, to make things difficult, and I guess English isn't a particularly easy language in many ways, we have 12 tenses. So we've mentioned 2 of them, future simple and future perfect, but we have 12 in total. And in the study guide, you'll see the little table where on the left-hand column, we have simple, continuous, perfect, and perfect continuous. And then across the top, we have in a row, past, present, future. So for example, simple past tense is I typed. Simple past tense is I typed. Perfect past tense, or past perfect tense rather, is I had typed. Future continuous tense is I will be typing. Or future perfect continuous is I will have been typing. In a way, all of these things are meant to say presumably the same thing. But by reference to the example in the study guide, you'll see that if you choose to change the tense in the language, then it may affect change of substance in the meaning. The other thing that I'd caution you to consider is this, that when you're reading material and it just doesn't quite seem to flow, it just doesn't quite seem right, it may be that the author, the writer, has switched between, for example, present perfect to present simple, or future simple to future perfect continuous. Do you understand what I mean? So that if you're preparing something for the sake of uniformity and clarity, it's best to try to keep it simple and consistent. Conversely, if you're looking at the language used by someone else, particularly, for example, in the context of a legal argument, your opponent, you may be able to use your careful analysis of the language to win a case. But of course, remember that the hunter may become the hunted in that sense. So in law, in simple terms, grammar matters. And the way in which you use your words may ultimately be the difference between your client having an enforceable right and something which is unenforceable. It might make the difference between victory and defeat. It might make the difference between prison and freedom. And I hope you understand what I mean. So be precise. And when it comes to reading your assessment work, remember that I will be looking to consider your ability to convey a message accurately and concisely. You should by now have a very simple list of definitions for key grammatical terms, so that you have a very clear idea of what is a noun or a proper noun, pronoun, adjective, verb, adverb, preposition, conjunction, and as we've discussed tonight, clause, principal clause, or independent clause, and subordinate clause or dependent clause or phrase. And sometimes the wording will be slightly different, but you should have some definition written down for each of those things, and probably an example that will help you by way of reminder. If you want to look at a very recent case that deals with an issue around the use of language and the tense, there's a decision of Baker against the Chief Executive, Department of Natural Resources and Mines, 2019 QCA 128. It was a decision of the Court of Appeal on the 25th of June 2019, and it related to the owner of a rural property having been convicted of contravening provisions of the now repealed Sustainable Planning Act of 2009. And there was some discussion there about the Vegetation Management Act as well. And the key discussion in that case, and you don't have to read it in full, but it's just to give an example of how this can actually go all the way to the Court of Appeal, was where the word or was at the end of each separate consideration under Section 20B of the Vegetation Management Act, whether it provided separate and distinct circumstances in which a decision maker may take certain action. So, what's a good writing style? Well, first, the basics. Make sure that you write with accurate grammar, and of course that you have appropriate punctuation and spelling. So if you like, they're the mandatory rules. So number one, the basics, grammar, punctuation, spelling. Number two, as for a good writing style, is something about your own style. And even though I keep saying write in the active voice using short sentences, as I mentioned earlier, given that we're at this advanced level, you can now feel comfortable in going beyond that and choosing a structure that works well for you. And that might involve the actual choice of words. In the case of verbs, the tense that you choose to use, and also the pacing is important. So good writers vary the length and complexity of their sentences for effect. But in legal writing, deviating too far from the norm can be distracting, and also it can create potential interpretation difficulties. So overall, legal writing is quite conventional. It is changing, and it has changed. So don't be tempted to be guided by the way in which people wrote in the 50s, 60s, 70s. Look at much more the way in which people write now. For example, in the district court, anything I think written by Judge Morzone QC is well worth reading because His Honour writes in a very simple, direct style, which is very easy to follow. Okay, so good grammar is a key for good communication. And not everyone can get this right, and it's easy to be confused. One of the problems is that people have a mindset. They know what they want to say, but they just don't say it with accuracy. With accuracy. So take this example. Mary used Jill's computer and phone, but didn't return it. Mary used Jill's computer and phone, but didn't return it. So what is it? She became angry when the power went out. Well, who is she? Jill, she contacted Jill and said, I know where you live. So it's all a bit confusing. All right, so the week 5 reading is part 4 of Ramsay. So this is the current text, but if you're reading from the previous version, part 4 contains the same chapters, which are chapters 28 to 40 inclusive It's just that the page numbers are different. So in the current version, the pages of 104 through to 134 inclusive, as opposed to the previous chapter, where part 4 was from 79 to 98 inclusive. So part 4 deals with legal vocabulary, and the overall topic is in the text, vocabulary and spelling. One of the, I guess, almost annoying but almost quaint things about law is that we use phrases that are Latin. We also use some French phrases. And we intermingle this with English. I don't think we use much by way of Indigenous language at all, which is really quite surprising now that I think about it. But you will need to be familiar to some degree with Latin and French and identify that background to the words or the phrases that might be used. So some of the common Latin phrases, again, I think you'll be able to read this in your textbook, but I'll give some examples that relate to law. So one is ab initio. You'll hear that quite often, particularly to follow the word void. So void ab initio. Ab initio means from the start. Actus reus means physical elements relevant to a crime. Affidavit means to have sworn on oath. So affidavit is usually a document. Bona vacantia is Latin meaning goods without an owner. Lex loci is the law of the place. Mandamus is we command. It's an order specifying something to be done by an official. That was very common in administrative law when I was first studying, but that's now been overturned because we have judicial review instead of writs of mandamus and certiorari. Mens rea means the guilty mind for criminal guilt. And then we have the nemo dat rule, nemo dat quod non habet, which means you cannot give what you do not have. So you'll see that in contract law, and we often just simply abbreviate it to the nemo dat rule. But it's Latin. I mentioned earlier certiorari, which was an old administrative law writ, and it means to quash a lower decision. Contra preferendum is any ambiguity is construed against the party proffering the document. So the basic rule is if someone prepares the document and it's ambiguous, then a court will, as its first instinct, hold that ambiguity against the party that prepared the document. Contra preferendum. Eudestum generis is of the same type, and you would have seen that in statutory interpretation. Ex parte, you'll see this a lot. Ex parte means from one side only. So that's usually associated with work in civil litigation, or possibly in criminal law litigation as well, but usually courtroom context. So ex parte application means from one side only, without necessarily advising the other side. Extempore or extempore means out of time without preparation. So extempore decisions are handed down by magistrates, judges, tribunal members on the run at the time, as opposed to a reserved decision, which will come later. Functus officio means having performed his or her office, then that's Latin. So, for example, if a court or a tribunal makes a decision, announces the decision, and then someone walks in and says, look, I'm here for this case, it's tempting for the presiding officer to say, oh, look, I didn't realise you were here. Look, let's now start and we'll hear the case, we'll hear your evidence. It's too late. Once the presiding officer has announced the decision, then that tribunal or court is functus officio. Habeas corpus means you must produce the body. In camera doesn't sound Latin, but what it means is in chambers, not in a public session. So in camera means essentially in private. Nolli prosequi, you'll hear this around the criminal law jurisdiction, and it means an intention not to proceed with a prosecution. It sounds all very technical, but it's really very simple in practice. So if after having presented an indictment, the DPP, the Crown, decide not to proceed with one or more charges on that indictment, they'll ask for a return of the indictment, and they'll enter what's called a nolli prosequi by writing on the indictment. Essentially, the Crown is not proceeding with this indictment or these counts on the indictment. Obiter dictum, you would have heard that in Introduction to Law probably, or statutory interpretation. It means basically, in the context of a court decision, something said by the court which is not fundamental to the making of the decision or the order under consideration, but it's a statement made in passing, effectively. Quantum meruit is, again, Latin, and you'll hear this primarily in things like building disputes or contract disputes, and it's essentially used almost always as an alternative to a claim that would have been made directly under contract in circumstances where, for some technical reason usually, you can't proceed with a direct claim. So what you claim is a quantum meruit claim, which is, well, I may not be technically entitled under black letter law to proceed, but I should be entitled to receive something that I deserve. So that's quantum meruit. Res gestae is things done in the course of the action, and you'll come across res gestae in evidence law. So usually in the context of the admissibility of hearsay evidence within a res gestae context. Res ipsa loquitur is a Latin phrase meaning the thing speaks for itself, and you'll come across that primarily in torts law. So in negligence, for example, or some other tort, it may be impossible to actually prove something occurred, but the argument around res ipsa loquitur is, well, it happened, and that really speaks for itself. Res judicata means the matter has been determined. It's a little bit like functus officio, but it means usually not at the moment. So in the past, the matter's already been determined, so it's usually a plea. So you'll see res judicata in civil litigation, civil procedure. Subpoena is an instruction that must be followed to avoid a penalty. Again, you'll see that in the context of court matters, civil or criminal. Ultra vires means beyond the power. And you'll come across that term ultra vires in administrative law, usually in the context of an argument that a court or a government made a decision which went beyond the power conferred upon it, so therefore it's void and of no effect. That's the argument. So an ultra vires argument is beyond the power. Verbatim means word for word. And verbatim is one of the few of the Latin terms that are used in law that is actually used in a wider context as well. Some other ones are in personam, means against the person, and you'll see that usually in property law as opposed to an in rem claim, which is against the land. An in personam action is against the person. Another term is in re, means in the matter of. Okay, so that's the Latin. Just a few things. So I will just say this though. It surprises me that we still use these Latin terms in law, but we do. So all of the ones that I've mentioned tonight, you'll use them, you'll hear them quite commonly in practice. I wonder if it's sometimes used to make that which is ultimately fairly straightforward and simple sound much more difficult. So you might imagine a situation where a lawyer unaccustomed to criminal law practice rejects a brief on the ground that the client wants to, so there's a request for approaching the other side for a nolle prosequi, and you think, well, that sounds very technical, but really it's very simple. Now, French is less common than Latin in the legal context, but it's still there. So attorney means a person appointed, so that's French derivation. Autrefois acquit, you'll hear this in criminal law, meaning opposing a new prosecution where there's already been an acquittal. Cesti qui trust means a beneficiary, so you'll come across that in French, French phrase in trusts law and equity. Chattel means a thing. Chose means a cause, so a chosen action. Usually you'll see that in some form of civil litigation. Estoppel, dealing with equity, it's an equitable principle, means to block. Mortgage, this is an interesting one, means a pledge until death, which might seem if you take out a mortgage. Torts is French and it means wrongs. And voir dire means technically to speak the truth, but you'll come across the term voir dire usually in the context of criminal law, where it is, as we describe it, a trial within a trial in the absence of a jury. So they're just some of the terms that you'll come across. Now, when you're using vocabulary and spelling, you need to be aware of some of the sins of past drafting, particularly legalese, and take care with words that amount to legalese, herein before, etc. Some of the examples that you might think are legitimate, but they're really legalese and to be avoided, are things like the use of the word same or such or said in the context of the said contract, or in relation to same. So all of those things we need to avoid, and please avoid that when you're drafting your material. So when they're used in the wrong context, they can actually be misleading or ambiguous. At best, they're pompous in the way in which they read. So sometimes shall is used superfluously. So just be careful about the use of the word shall. And again, just coming back to the words same and said, examples of that might be this: the contractor shall collect the concrete and deliver same to the building site. So we don't think of a better way of saying it than that. And also don't say something like the said contract. We don't do that anymore either. Some commentary in the text about, I think, devise, demise, and determine. So these can be difficult in law because they may have a technical meaning as well as a common meaning. So just be very careful about those words that are different in the legal English as opposed to common English. So in legal use, to determine does not mean to decide, but rather to end or conclude in some contexts. So in contract law or property law, for example, if a lease is determined, it means to come to an end or conclude. And likewise, devise or demise in legal sense means to transfer title. So you'll come across that in property law. But in common English, they mean to devise a scheme or a plan. Or in the case of demise, to die or fall from grace. So different meanings. So try to avoid those words that have a technical legal meaning. If you do use them, then under rules of statutory interpretation, we will look at the legal meaning as opposed to the common English meaning. And of course, in the context of legalese and proper drafting, avoid the archaic words such as hereinafter, wheresoever, aforesaid. They might sound, to some people, they might sound, I don't know, very knowledgeable if you use those words, or lawyerly, to make it feel like you're a lawyer, but we don't want to go there. Also, do try to avoid using unnecessary additional words. Sometimes lawyers in the past were guilty of this. I think lawyers were paid for, even when I started, and to some degree still, lawyers are paid by the number of words that are used. So, of course, it's in the financial interest of the lawyer for documents to be verbose, to be as wordy as possible. Then you get more money, and it's easier to draft a wordy document than it is to draft something that's very precise. So documents became much more wordy, they became far less efficient, and that was rewarded financially. So that pay by the word system is largely now out of date, not entirely, but largely. And there are some telltale signs of padding in the words. Please don't do this for your assessment work that you present to me. I'll give you some examples. There are some superfluous words, and they're used within a phrase that would work perfectly well without them. For example, and we're almost finished for tonight, the parties covenant and agree. Well, why do we need the words covenant and? It works just as well if we say the parties agree. The tenant shall have full use and enjoyment of. We see that a lot. Why do we need to say an enjoyment? It's archaic. It adds nothing. The words would have used the tenant shall have full use of the property works just as well. This is a certified true copy. Well, if it's a copy, it's a copy. Why do we have to say true? So get rid of that word true. He is exercising his lawful authority. Well, maybe you could argue that that word lawful is necessary, but I'm not sure it is. So in wrapping up for tonight, and thank you very much, Nicole, and those of you watching this as a recorded session, for your patience. What do we take from part 4 of the text in relation to vocabulary and spelling? Well, write simply. Avoid legalese. Take out superfluous words. Ensure that you write in a form that makes ambiguity less likely. Don't add words unless they add something. We talked at the start this evening of clauses and phrases that actually add something legitimately to the meaning. Conversely, at the tail end of what we've done tonight, we've talked about words that were added that have no meaning. So if you add words, ensure that they add to the meaning of the sentence. If you add words and they add no meaning, that's poor drafting, but it might actually lead to ambiguity, which is even worse. All right, well, we'll wrap up for this evening. If there are no questions or comments, remember that we will have a session in 2 weeks from tonight, which will be the 27th of August, so there'll be no session on Tuesday, the 20th of August. All good? All right. Thank you. So let's wrap up for tonight. All the best. Enjoy your break next week and catching up with your work. Bye then.